The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
Tonight on Closing Arguments. In Memphis, Tennessee, day one of the trial of Brandon Isabel, the man accused of murdering his girlfriend and tossing her 2-day-old baby into the Mississippi River. According to investigators, Brandon admitted to the killing of Kennedy and their baby because he didn't want a child. What more will we learn from today's opening statements? Plus, a South Carolina man accused of keeping 4 vulnerable people captive in his basement for a decade, abusing them and stealing their money, until allegedly one of those prisoners died from the abuse. Now we're learning more about the case against Donnie Ray Birchfield Jr. But first, for more than a decade, the Gilgo Beach murders cast a long, dark shadow over Long Island, leaving a community haunted by unanswered questions. In July 2023, the shroud began to lift as authorities apprehended a suspect whose unassuming facade seemed to contradict the horrors attributed to him. An architect charged with the cold-blooded murders of multiple women. His arrest sent shockwaves through the nation. And today, the accused Long Island serial killer was back in court, where the judge handed down several rulings that could seriously impact his defense. Good evening and welcome to Closing Arguments. I'm Julia Janae filling in tonight for Vinnie Politan. Thank you for being with us as we follow these new developments this hour in one of the biggest cases that we've been following here on Court TV. It involves 7 female victims and an alleged serial killer. And this is a case that began decades ago. And here's a look at those victims. First, in 1993, the body of Sandra Castillo was discovered by 2 hunters in a wooded area of North Sea on Long Island. And according to court documents, Castillo had several sharp force injuries across her body. Then came the partial remains of Jessica Taylor and Valerie Mack. In 2000, Valerie's partial remains were discovered by hikers in Manorville, New York. Her body had been cut into pieces and placed in plastic bags. Jessica Taylor's partial remains were discovered in Manorville in 2003. And in 2011, limbs and skulls belonging to Jessica and Valerie were located in Gilgo Beach. In 2010, the remains of 4 more victims, Megan Waterman, Maureen Brainerd Barnes, Amber Lynn Costello, and Melissa Bartholomew. They were found in Gilgo Beach. And more than 30 years since the discovery of the first victim's body, authorities say they have identified the so-called Long Island serial killer. But the question is, can they prove it? How will they prove it? Prosecutors say that DNA will put former Long Island architect Rex Heuermann behind bars. And today, a judge made a big ruling in the case. Prosecutors are allowed to use high-tech DNA never before used in a New York courtroom in the case against him. So we're going to focus on this new revelation. This is the second time the defense has tried to block this advanced DNA. And again, the first time it's being used in New York. So here to offer her expertise on this case is forensic DNA expert and president of Identifiers International. We have Colleen Fitzpatrick with us. Colleen, thank you so much for breaking this down for us. And as I mentioned, first time in a New York courtroom. Can you talk about why this is such a big deal?
Well, for years, the legal system has used CODIS, the CODIS system, which is a profile of 20 markers called short tandem repeats. And these markers have been well characterized. They've been ruled admissible in court a long time ago. They're repeatable. They're very, the system has very high confidence in these markers, identifying this population statistics. It's, really well known. So now this involves a different kind of marker called a SNP. And SNPs have been around a long time, but they have never really been used in legally for human identification. So the genetic genealogy community, forensic genetic genealogy, has become a way of generating investigative leads using SNPs. And we only generate investigative leads for this, but because that marker has become so valuable in this kind of work, it is now logical that it should be used for official human identification. And it's like another kind of way you can do it. You don't have to rely on CODIS anymore. But of course, it has to be ruled admissible in court before it can be, used legally.
Sure. And human identification is huge here. We've got multiple victims who were discovered over different years in varying states, varying ways that they were disposed of and their bodies where they were located. So can you tell me, I know this company, Estrella, is the one who the testing is attributed to. Can you talk about what the advanced testing shows that may not have been there previously? Is it that simple? Is there something different that prosecutors are now going to be able to show that they couldn't before in the case against Rex Heuermann?
Well, yeah, because what happens is the case rests on rootless hair, and you can't get STRs reliably out of rootless hair. And so now you can only get SNPs out of the rootless hair. So now it becomes, without that, you have to rely on circumstantial evidence. But if that's ruled admissible in court, then you have, you have a DNA way of using DNA that can be used for the identification process. You don't have to rely just on circumstantial evidence.
Let's talk about the DNA. Let's remind everyone, because this is a case where you have, like I said, those 7 different individuals, but there's not necessarily DNA that's directly connected to Rex Heuermann on all of them. Is that right? Can you recap what DNA they do have and how that connects to Rex Heuermann?
Well, yes, I believe what happened is they originally found a hair in one of the burlap sacks that contained one of the bodies. I can't remember which one. And so from that hair, they were able to extract mitochondrial DNA, which has been used quite a bit in a lot of identifications. And they were able to match that to the DNA on the pizza box that they found that he had discarded. And subsequently, after he was arrested, he had to give a buccal swab, which matched him directly to the hair found in the burlap sack. They didn't have to rely on the pizza anymore. So from that then, all right, he has, that rules out 99.9% of the population. So from that now, that's just mitochondrial DNA. It goes along the female line of the family. There are other people that have that same mitochondrial. But furthermore, now that gets into SNPs, because that's how mito's done with SNPs. And then you get to the hair now. In recent years, you've been able to extract the whole genome from hair, much more DNA, nuclear DNA. And that goes into, can you use that to identify that particular person and not just that kind of person with that kind of mitochondrial DNA? It's much more powerful than mitochondrial or CODIS. But it's a new way of doing things, and it has a long history. So all of that has to be reviewed in order to go into the legal system. It's much more powerful, though.
Yeah, being in the legal system is the big question, and whether or not it's been tested by the courts. This will be the first time there in New York. There is terminology about damaged samples. The New York Post reporting that that's part of this, that the DNA that was processed by these labs, that the defense is saying they allow these damaged samples to be used. Would you characterize the samples as damaged, and is that a problem when we think about a potential appeal in this case if there is a conviction?
Honestly, I don't think there's going to be a problem as far as the science goes. What happens is you take the hair, you do something called whole genome sequencing, which is basically you generate an electronic copy of the DNA. And if it's damaged, there'll be gaps in it. And you use a software technique called imputation, where you take your unknown DNA, you compare it to the standard human genome, and you can fill in a lot of the gaps. There's certain logic to that. All humans are 97, 98, 99% the same. So if you do have gaps, it's, you use certain techniques to fill those in. So that has been used, and many times over time. Imputation has been used not only for rootless hair, but for other damaged DNA. We've used it many times. And so the admissibility kind of did not depend on the whole genome sequencing, but more like the repair, the software, IBD-GEM, that was used to repair that damaged DNA. But from reading the judge's ruling and the resumes of Dr. Green, Dr. Navrosky, Dr. Harris, who really did the work, you know, they ran thousands of cases to make sure that their software worked. You just don't say, hey, it works, and you throw out some numbers. You have to make sure that it works, and they ran thousands of cases where they knew the DNA matched, you know, to DNA match. They took a supposed unknown, and then they ran it against a bunch of people, and it matched or it didn't, and it was always 100% correct, whether it was the person or was not the person. And then they looked at errors that could possibly come up with the software and whether they affected that decision or that outcome, and they really didn't. So of all the many, many cases that they used to test the software before going and running it in this case, you know, showed it was, you know, basically reliable. It was reliable 100% of the time. So if you go to the appeals, you start talking about this, you know, you almost can't go against that. It's just been tested like crazy, and enough to be considered reliable in the scientific community. And that's what the Fry hearing came up with.
Colleen Fitzpatrick, president of Identifiers International, thank you for helping us break down that complex science about DNA. We appreciate it, and I want to turn now to our think tank that we have with us so we can talk about some other things that happened today in the Rex Heuermann case. We have criminal defense attorney and former head New Jersey County prosecutor Bob Bianchi with us, and criminal defense attorney Charles Milstead is with us, and criminal defense and family law attorney Allie Croft-Hamill. Thank you all for being on. We've got all attorneys who are experienced and understand how things can change in a case like this. Yeah,
we have one investigator.
One investigator. That's right, Charles. Yeah, we got two attorneys and one investigator. Thank you for correcting me. Let's start with you, Bob, though. We're talking about something new in New York. This DNA evidence, advanced technology being allowed in. Where do you stand on this?
Okay, as a former homicide prosecutor, I'm very, very comfortable with this evidence. Your guest did a phenomenal job before we got on breaking this down, and so your audience understands. Expert witnesses are only allowed to testify if it passes what they call the Fry standard. The Fry standard, F-R-Y-E, is an actual case that says before scientific evidence, quote unquote, is allowed to be admitted, Charles will talk about this a little bit later as a scientist, or an investigator rather, you have to make sure that it is scientifically reliable. You just can't throw junk out there. And you have a standard here, a new way of doing DNA evidence. But there was a time when I started, believe it or not, that DNA was new. All of DNA was new. So since the 90s, the courts have said DNA is admissible because it's generally accepted science. It's reliable. Whether the jury accepts it or not, it's a different question, but we're going to allow it to be admitted. Here's a new form of analysis now that's close to 100% accurate. And so from a legal point of view, from a prosecutorial point of view, I always have to worry about, will this get reversed on appeal? But I'm not here because the judge made a very competent ruling after listening to experts that this in fact is more reliable than other DNA evidence in the past, and that is the only thing that counts. So this is a big win for prosecutors, and this ruling will not be disturbed, in my humble opinion, on appeal, and certainly it's going to be very powerful evidence against the defendant in terms of guilt.
And this is the second time that the judge has denied this motion by the defense to try and keep it out. Charles Milstead, criminal defense investigator, are you concerned about the advanced technology that is going to be allowed inside of a courtroom, and what is that going to mean for criminal defense cases?
No, I'm not concerned at all. I mean, the science works both against and in favor of criminal defendants. So, you know, the defense community is just as interested in getting at the truth and having reliable science that has been subjected to the prize standard, and so I don't think this changes anything, you know, from a defense perspective in terms of how the community looks at this. Naturally, there's still going to be issues that have to pass the the sniff test as far as the collection methods, crime scene processing, the credentials of the experts that present the evidence, that conduct the analysis, et cetera. All of those things are going to continue to be very important for defense lawyers to look at, to ensure that they have consulted with other opinions, other experts, to ensure that the science as it's being presented is in fact being presented in a way that is applicable to what the state or the government is trying to bring out in their case in chief.
Yeah, absolutely. Ali, let me ask you about something else that happened today inside of that courtroom. The judge denying a request to sever these cases into two individual trials. They want the deaths that happened from the 90s to the early 2000s to be separated from the ones that were killed 2009 to 2011. And there's DNA evidence, but not on all of these bodies. So how important was it for the prosecutors to get this positive ruling where they're going to keep all the cases together? Can they perhaps use that to tie everything together?
Yeah, I think that's significant for the prosecution. Of course, their theory is that he is a serial killer, right? So they want to tie this all together. And it's more likely that if the jury believes that he committed one of the killings, that he committed all of the killings or more than one of them, especially if the theory that they keep harping on in their closing and their opening arguments is that he is a serial killer. So I think it's significant for the prosecution. In addition, the judge and the taxpayers will have to pay for one jury trial to hear all of the evidence at one time rather than 7 separate trials. So I think that's also significant for the state.
And there was something that the judge mentioned in that order, and that had to do with this planner, this murder planner, when we've got victims from 1993 to 2010. DNA is not the only evidence they say they have. They say they have that planner, and in the court documents, they describe some of the things that Rex Heuermann put in this document. Our producer breaks down the details.
In March 2024, the Gilgo Homicide Task Force extracted a Microsoft Word document entitled HK200204 from Heuermann's laptop computer. The task force members believe the Microsoft Word document to be a planning document utilized by Heuermann to methodically blueprint and plan out his kills. The HK planning document begins with the 4-category section with the underlined headings of problems, supplies, DS, and TRG. It is believed the DS heading appears to be an acronym for dump site, which is corroborated by the discovery of Valerie Mack at 2 separate dump sites, one of those locations being the vicinity of Mill Road, which is listed as DS-1 Mill Road. As detailed previously, TRG appears to be a reference to target or victim. At the time of Miss Mack's disappearance and murder, she was approximately 5 feet tall and weighed less than 110 pounds, fitting the small is good note. The members believe supplies to be a reference to what supplies are needed to carry out the serial murders. One of the listed supplies is foam drain cleaner. A review of Heuermann's Nextel cellular phone records reveals that on October 3rd, 2000, Heuermann appears to make 2 outgoing calls to a plumbing company based in Lynbrook. In mid-November 2000, Heuermann paid $265.83 to yet another plumbing company to check his mainline drain. The supplies section also includes notes to utilize rope or cord and bags and tape, each of which were recovered with the remains of the victim. The HK planning document contains a body prep section with a note to remove head and hands, which clearly relates to the condition of Valerie Mack's remains. Additionally, Valerie Mack was indeed packaged for transport, as this section indicates to do. Finally, the body prep section above includes a note to remove ID marks, tattoos. The Gilgo Homicide Task Force interviewed several witnesses who confirmed Valerie Mack had a tattoo on her foot or ankle which depicted her son's name. The Gilgo Homicide Task Force members believe the defendant amputated Miss Mack's lower right leg at the mid-calf to inhibit and/or delay the identification of Miss Mack's tattoo and therefore Miss Mack.
Bob Bianchi, bring back in the think tape and let me ask you what you think about this planner and what does it tell you about this defendant? It's very organized, it seems.
I've been dealing with murder cases an entire career and have seen some pretty ugly cases that I've personally prosecuted. Just listening to this, though, with all that experience, just gives you the chills. The methodical nature of this, like you can kind of get your arms around cases where it's heat of the passion or, you know, something happens, you get angry. But this is a systematic, planned out way to kill somebody. And even I, an experienced homicide prosecutor and criminal defense attorney, cringe when I listen to this. It got me really, really uncomfortable. Okay, let's go to the evidence. This piece of evidence was key. It unlocked a door. And what it unlocked was the opportunity for prosecutors to argue that all of the murders should be tried in one case, because typically speaking, that would be considered unduly prejudicial in many instances under an evidence rule that we normally refer to as evidence rule 404, other act evidence. But prosecutors were able to say there's an exception to that rule. And the exception is planning, modus operandi, the way that they're doing things in a continuing plan or pattern of activity. And that planner is keying in for prosecutors the ability to say this wasn't a one and done. It was multiple individuals. He was training, learning, and doing things consistently from one death to the other. And that's why the court then said the probative value of all of them together is greater than the prejudicial effect by having them all tried at one time. So this was not a willy-nilly ruling. This is one that's very complex, very nuanced. Prosecutors were very, very careful, because if you go over the line and down the road, if you get a conviction and it gets reversed on appeal, who wants that? But I think the judge made the right ruling, because that diary opened up the door to say that this wasn't a one and done, that this was a systematic attempt to kill multiple people.
Yeah, you mentioned modus operandi. In that planner, there's this mention of MO-problem, meaning, or what the prosecution says means that this defendant felt like that was a problem for him in this case. Should he ever be caught? Should be a jump perhaps for the defense, but we're going to leave it there, keep you updated on what happens in that case. We still don't have a trial date on this one, but they have more to unpack there. The think tank is staying with us. When we come back from this break, we'll bring you the latest details in a case of a man who's accused of holding 4 people captive for years. Plus, here's what's coming up in the next hour on VPI. Tonight on Vinnie Politan Investigates, the body of would-be 15-year-old Celeste Rivas Hernandez was found in the front trunk of an abandoned Tesla, registered to popular artist David. Were the two connected? We investigate.
The Court TV podcast will return.
Welcome back to Closing Arguments. I'm Julia Janae. We are following a story out of South Carolina, learning new details where a man is accused of holding 4 people captive in his basement. His name is Donnie Ray Birchfield Jr. Authorities say he wasn't caught until one of his captives died from the abuse. So let's get right out to Court TV field reporter Cody Thomas, who's here in studio with us to tell us the latest on this strange but really disturbing case. Cody.
Absolutely strange and disturbing, to say the least. Great to see you, Julia, as always. So this suspect in this case, 35-year-old Donnie Ray Birchfield III, is facing a handful of serious charges, including aggravated assault, 4 counts of false imprisonment, 2 counts of abusing a vulnerable adult, along with various other financial crimes. Now, according to the incident report, he was arrested in early August after police responded to his home after they received a report of an unattended death. Now, that's when investigators discovered he was keeping 4 individuals in his basement, abusing them and depriving them of the necessary nutrition and medical treatment that they needed. Now, the incident report kept the victims' names and ages redacted, and it also kept the identity of the person who alerted the police of the dead woman private as well. But what we do know is that among those 4 victims, it was a man and a woman who were married. Now, the married woman was the one who died, and police say Birchfield was her caregiver. Now, the other 2 victims were women who were allegedly in romantic relationships with Birchfield, according to the court documents. One of those women had lived with him since September of last year, while the other had been in the home since 2015, so that's a decade. Now, it's unclear how long the married couple had been living there, but arrest documents say the victims only left the basement when Birchfield allowed it. Now, what you're seeing on your screen right now are photos of Donnie Birchfield obtained from the Facebook pages of his mother, Wynette Wentz Birchfield, and his sister, Gracie Birchfield. Now, along with the abuse and neglect charges, he also faces financial exploitation charges related to these victims. The incident report says in part, it was discovered that the listed suspect did obtain and withhold at least 2 financial transaction cards belonging to the victim without the victim's consent. The listed suspect did financially exploit the victim by using funds from these financial transaction cards to purchase services for himself without authorization by the vulnerable adult. The listed suspect did purchase services for himself from the same vendor on 23 different dates between November 4th, 2022 and September 3rd, 2024. Now, he continued to financially exploit the victim by making payments toward his personal transactional cards from the victim's personal bank account. So to simplify all of that, over the period of time listed in the incident report, Birchfield was abusing these 4 victims and using their money for his own personal use for dozens of purchases and paying off his own credit card debt in the neighborhood of $12,000, according to that report, Julia.
What was happening in this house, Cody? That is unbelievable details. Still a lot more that we don't know. Thank you so much for updating us on what those details are. Let's bring back in the think tank. Still with us, Bob Bianchi, Charles Milstad, and Allie Crothhamel. Charles, let's start with you. If you're investigating this case, what's the main thing that you want to know here?
Yeah, again, this is pretty disturbing allegations, and anytime you have someone who is responsible for a vulnerable population and is in charge of their welfare, and there's the potential for exploitation. But this is the type of case that I've had on previous occasions, and you have to be very careful in sort of examining a lot of the facts surrounding the care, the financial component to it. And the good news is that there generally is a decent amount of evidence available to facilitate that sort of probe and that sort of investigation in terms of how those proceeds are coming in, how they are benefiting the person whose care is at issue, and also how the reporting took place, whether there's some relatives that may have made a report, whether there's some sort of conflict there, or maybe a relative who felt deprived from caring for another relative. So there's a lot to untangle here, but getting to the bottom of this sort of case is truly very important, just because it's a very, very unfortunate thing when someone who is has been placed in the custody of somebody that is designed to keep them safe and cared for is being abused or exploited in some way. But generally, there's a lot of evidence here to bring some light to this type of case.
Yeah, we really need to understand these relationships, Allie. We don't know if there were any kind of official guardianships between this defendant and the people who were found in the home. According to the report, we've got this perhaps relationship between the defendant and some of the people that were in this home, and one that was there for at least a decade. I'm concerned about why all of these people were there and no one had alerted authorities. We don't know about that yet, but what's standing out to you?
Yeah, so it's kind of peculiar to me, Julia, these relationships and also where their families were, right? So you have people that are being held captive in a basement upwards of a decade, and I'm assuming they haven't gone to the doctor, the grocery store, the dentist, seen their family. Where are those people? You know, your normal contacts every day, where are they? It's very odd, and if they're not related, you have 3 different people, you know, you're presuming 3 different families. So what is he telling the families or telling the victims to tell the families? Very odd.
Bob Bianchi, I want you to put on, I know you're a former prosecutor, but I want you to put on your criminal defense attorney hat and tell me what possibly the defense could argue in this case if everything that we've already heard so far outside of the abuse, according to Cody's report, if that's all true, if he did have these people down there that long, if he was using their credit cards, what is your argument here?
Okay, well, listen, any good prosecutor is going to look to see what a good criminal defense lawyer would do here, and I do criminal defense, so we got it all here in one spot. Listen, I don't even know what this case is about. I don't know any of the facts. I know everyone is talking about how horrible it is, and I get it. Taking advantage of a vulnerable population of people is a bad thing to do. But some of the notes that have been said here today are, is there a legal responsibility? Is there some sort of care and custody agreement? Were these people mentally ill? Were they physically incapacitated? Look, there are cases across the United States of America right now where families are arguing that one sister, one brother, one family member took advantage of somebody who was elderly or got them to sign agreements or misappropriated their funds. As a prosecutor and as a criminal defense lawyer, I've got to be very careful before I start jumping to conclusions. I don't know what being a vulnerable adult means here, and I don't know specifically what facts show that these things were not consented to. I've literally had cases as a prosecutor where family members filed charges and said that it was a vulnerable person and that money was stolen, only to find out that these people were completely mentally capable of making a decision and gave that person the right to be able to take the money and to do the things they did. You may not like it. You may think it's unethical, but it doesn't make it criminal and illegal. Right now, jury's out with me. I don't know what vulnerable adult means and whether or not this guy crossed the line. They filed the complaint. I like to see the police reports and see what the evidence is. Something about this strikes me as being, as we say in the business, squirrely.
It is an odd case, and this defendant would definitely benefit from an attorney like Bob Bianchi on a case like this. Let's get to our break. We will continue to follow details there and let you know what happens once this case actually gets in front of a judge. But when we come back, we're going to look at the opening statements of this tragic case. This one's in the South as well, in Tennessee, and it is the state versus Brandon Isabel, and it involves a 2-day-old baby being thrown into a river. Stay with us.
Now, back to the Court TV podcast.
On the first day of February in 2022, a police officer on a routine patrol finds an abandoned car with a broken window. Then, a startling discovery. Beside that car, the body of 27-year-old Danielle Hoyle. She had been fatally shot. Relatives told police Hoyle had her 2-day-old daughter named Kennedy with her, and she was there to meet with the baby's father, Brandon Isabel.
Danielle, she missed by everybody. Like I say, young folks make mistakes, but that wasn't a mistake. There wasn't a reason to kill my daughter.
Brandon Isabel admitted to police to shooting Danielle Hoyle and to taking their newborn to the Mud Island boat ramp, where he tossed the baby into the Mississippi River. The baby's grandmother talked with WMC TV.
I want him to suffer like he made my baby suffer. I want him to hurt. I don't want it to be easy for him. I want him to suffer. He needs to suffer. Why would you hurt a baby?
A 5-day search in the frigid waters turned up no sign of baby Kennedy, whose body has never been found. Brandon Isabel is charged with 2 counts of first-degree murder, aggravated child abuse and neglect, and aggravated kidnapping. He has pleaded not guilty.
Why would you hurt a baby? That grandmother's line that she just said, that explains it all. That was Court TV anchor Michael Ayala with the backstory on one of the newest live trials that we're following here on Court TV. And today, we heard opening statements in the case of Tennessee versus Brandon Isabella. How is his defense going to handle this, especially if the prosecution says he admitted to it? Let's take a listen to first the state of Tennessee and then Isabella's defense.
The defendant convinced Danielle to drive down Sedgwick Road where it meets Levi, a desolate, deserted, dark road. Danielle pulled to the side of the road, parked the wrong way. The defendant exited his vehicle, opened the passenger door, and fired 5 shots into Danielle's car, striking her in the face and the head. He dragged her body from the car, leaving her face down in a ditch. He took Kennedy from her car seat, grabbed her by the leg, and threw her into the cold, dark water, not realizing that her little baby cap had fallen from her head and lay resting on the riverbank. Danielle's family is out looking for him. They want to know where Danielle and the baby are. So Artesia drives him back to Blackberry in Cordova. That's where the defendant and Artesia Stewart are detained by the Memphis Police Department. Sergeants Wimbush and Boyd, with homicide, began to question the defendant. And through that questioning, it becomes apparent that they need to go to Mud Island. And so a frantic search begins for baby Kennedy on Mud Island.
You can't know for sure if truth is being told to you. And that's understandable. Truth rings like a bell on a clear day. Truth does not lend itself to interpretations. Different scenarios, different interpretations. Beyond a reasonable doubt is like the same thing. If there are two reasonable, supported by the evidence interpretations, at the end of this proof, and both are reasonable, the verdict must be not guilty. Asking to hold the state to that burden of proof.
There was a very short opening statement by the defense. Our think tank is still with us. Let's talk to them about this case. Bob Bianchi, Charles Milstead, and Allie Crofthamel. Let me start with you, Allie. Why are we at a trial here, do you think? If this is someone who admitted to the shooting, these details, the victims here, it's just horrific all around, but yet they are going in front of this jury.
You know, Julie, I was thinking that as I was listening to the opening statements, I didn't hear anything besides the word truth and reasonable doubt, which as a defense attorney, sometimes that's the only thing you have to say in front of a jury. But with a full admission that I'm assuming is coming into evidence that will be presented to the jury, this is a bit alarming. But as a lawyer, you cannot force your client to plead guilty. They have to make that decision knowingly, intelligently, and voluntarily. And if this is not something he wants to admit to, then unfortunately, the only other thing you could do is put 12 in a box and pray. But this case doesn't lend itself, in my opinion, thus far, hearing the evidence that this will be a not guilty verdict.
Oh, yeah. Bob Bianchi, let me talk to you about it because I've sat through jury selections for cases involving kids, babies, and you have juror after juror during voir dire saying, I can't be fair and impartial in a case that involves a child. These are particularly difficult for jurors to sit through, especially a detail like this, a child just discarded into the river. What do you think about the fact that we're at trial and the defense pretty much just spent 2 minutes telling this jury that you have to pay attention to all of the evidence, reasonable doubt, but not really giving them much to chew on?
The most unenvious defense lawyer in the United States of America was that man that was standing up before that jury with literally nothing to say, but doing a job he's supposed to do to protect the constitutional rights of everyone. My question is, as I'm listening to this case, and I must be missing something. I am not a big death penalty guy. I've tried death penalty cases as a prosecutor, and I really don't trust the system that much to make these calls. But I looked up, and Tennessee is a death penalty state. Of course they're going to try the case. They've got nothing to lose. Why not take a shot? Throw the Hail Mary pass. But if the death penalty was on the table, it would be a different situation. And as a prosecutor, strategically, I may be able to get a plea to life without parole if I choose to do that, or go the full route and see what the jury says, because he's going to get life without parole anyway. I must be missing something, because I looked at Tennessee's aggravating factors for the death penalty, and felony kidnapping, that poor baby was kidnapped under the age of 12 years old, is another aggravating factor. I'd even argue heinous and cruel manner of death and multiple victims. So I honestly, I think I may be making a mistake, because if there was a case that had death penalty written on it, it's this one. And because they didn't, now they have, the defense has no strategic reason not to just go to trial and see what happens.
You know, Bob, a follow-up on that, the grandmother, when we played the story where she was giving that interview, she said something that stood out, where she said, you know, I don't care if it was a mistake, you should never do something to harm a baby. And that made me wonder where she even got the language that he may have made a mistake. He actually said in an Apple Watch message that police were able to get, quote, let's end this mistake, Danielle. Meaning she was the mistake that he wanted to get rid of. This was before she was killed. So is there some kind of, perhaps if there's a mental health issue there, do you think that that could not necessarily come out during the openings, but could be a consideration by prosecutors?
It's the only place to go. I always say anybody who commits a murder is mentally ill, but it doesn't necessarily meet the definition of mental illness, which is the inability to know the difference between right and wrong. But I do want to take what you just said. And look, as a prosecutor, when I'm evaluating conduct and I'm judging conduct, not people, conduct, I'm looking at how bad is this? Look, this guy literally, in terms of mental health, was able to make a phone call, lured her to the location for this specific purpose, took a weapon, fired 5 times to kill her, took the baby purposefully. I'm using this because it goes against mental health defenses. Do you have goal-oriented conduct? Threw the baby in the Mississippi and then went to Walgreens to buy his then girlfriend gifts. That's about as bad as you could get in terms of conduct. And he literally confesses, so strength of the case, strength of the proof, and then gives you the motive. I didn't want to have to deal with this child. I mean, this is literally one of the worst cases that scream out for the death penalty, which is one of the reasons I'm against the death penalty, because it's so arbitrary. Some people get it for nothing, and people like this don't. I don't understand it.
Oh, and we have just run out of time to talk about this case, but our think tank, thank you so much for weighing in on it and for all of it this hour. We have Bob Bianchi, Charles Milstat, and Allie Crothamill. Thanks for being with us. We are going to take a quick break. When we come back, though, it is time for us to reveal something else you need to know. Plus, take a look at this coming up on Vinnie Politan Investigates. Tonight on VPI. David's songs and social media pages have been growing in popularity. He now finds himself at the center of a homicide investigation involving a teenage girl. Could his songs, like Romantic Homicide, be used as evidence against him?
This is the Court TV Podcast.
We have reached the point in the show where we reveal something else you need to know tonight. New evidence and crime scene photos have been released in the Idaho student murders investigation. The killer of those 4 students is serving a life sentence after pleading guilty to the murders of those University of Idaho students. And we're seeing the white Elantra that he drove to commit these brutal murders. And according to the probable cause affidavit, he was seen leaving the scene at a high rate of speed. And that could be what caused these visible tire marks that there are photos of that have been released. Investigators photographed this on the road outside of 1122 King Road. And take a look at this. We're looking at a fingerprint marker and fingerprints on the window located on the 2nd floor near the kitchen and sliding glass door. Prosecutors say the killer entered and exited the home through that sliding door. And then finally, on the inside of that window in the kitchen, you can see a brown paper bag, a Jack-in-the-Box delivery bag that we know Xana Kernodle had ordered a DoorDash delivery from there that night. This is the first time we've seen images of those items that were left in the kitchen. We'll, of course, continue to follow that story and any developments as investigators continue to release documents and photographs that prior to that plea agreement, they were not permitted to release. Before we end this hour, there's a picture that I want to show you. This is Demaya Hall. Demaya is 17 years old. She was last seen in Memphis, Tennessee on September 18th. If you have any idea where Demaya is tonight, please call the Memphis Police Department. The number is 901-545-2677. You can also always call 911 or 1-800-THE-LOST. Let's see if we can get Demaya to a safe place tonight. And as we leave, don't go away, because we do have another hour of live true crime coming up next on Vinnie Politan Investigates.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.